They keep telling us the era of big Second Amendment fights is over. I'm here to tell you that's flat out wrong. Right now, Grant v. Lamont, a challenge to Connecticut's assault weapons ban, is knocking on the door of the Supreme Court of the United States. And what happens next will decide whether the most common rifle in America stays legal or gets written out of the Constitution by lower court word games. I'm speaking to every law-abiding gun owner who runs an AR for home defense, keeps a modern sporting rifle for training, or simply believes the Second Amendment means what Heller and Bruen already said it means. If courts can call 20-30 million semi-automatic rifles unusual and dangerous, and if cities like St. Paul, Minnesota, can pass bans they admit they can't enforce, then your rights, your safety, and the legal foundation of 2A are all on the line. In this video, I'm going to break down exactly how. Let's start with the basics. What exactly has Connecticut done? And why did it force ordinary gun owners into federal court in the early 1990s? And then again after later high-profile crimes. The state enacted and expanded an assault weapons scheme now codified in Connecticut General Statute Section 53, 202A through 53, 202 days. On paper, it reads like a technical definition. In practice, it is a sweeping prohibition that reaches far beyond a handful of exotic rifles. Under these provisions, Connecticut bans by name many AR-15 pattern rifles and, by feature, a broad class of semi-automatic rifles, pistols, and shotguns, threaded muzzles, collapsible stocks, pistol grips, and magazine configurations can turn otherwise ordinary defensive carbines into contraband. Unless a firearm was grandfathered under narrow exceptions, transferring, possessing, or even simply bringing one into the state can trigger criminal liability for otherwise law-abiding citizens. The state has also placed heavy burdens on dealers and manufacturers. Compliance requires navigating lists of banned models, constantly shifting definitions, and ambiguous, substantially similar language that leaves both police and citizens guessing. What started as a narrow reaction after a tragedy has grown into an enduring architecture of prohibition directed at rifles that millions of Americans still rely on for training, sport, and home defense. That is the legal environment Second Amendment Foundation and individual plaintiffs are living in. They are not hobbyists chasing a theoretical grievance. They are parents, homeowners, and working professionals who want to own and use the most common modern sporting rifle platform in America without being treated as criminals. When they asked a federal district court for a preliminary injunction to pause enforcement while their challenge went forward, the court refused, and the Second Circuit Court of Appeals signed off on that refusal. Grant v. Lamont, now styled Grant v. Rovella, is the vehicle they are using to ask the Supreme Court a simple but profound question. Can a state erase an entire class of commonly owned arms and still claim to respect the text and history of the Second Amendment? Once you see what Connecticut has outlawed, the next question is how courts are supposed to evaluate that kind of law under the Second Amendment, since District of Columbia v. Heller in 2008 and McDonald v. City of Chicago in 2010. The basic rule has been clear: the right to keep and bear arms is an individual right, and governments cannot flatly ban weapons that are in common use for lawful purposes. In 2022, the court went further in New York State Rifle and Pistol Association v. Bruen, rejecting the old two-step balancing tests and replacing them with a simple text and history standard. Under Bruen, the analysis should begin by asking whether the regulation burdens conduct covered by the plain text of the Second Amendment, keeping and bearing arms for self-defense and other lawful purposes. If the answer is yes, the law is presumptively unconstitutional, and the burden shifts to the government to justify it by pointing to a historical tradition of similar regulation from around 1791, or at least the Reconstruction era. Modern policy preferences and generalized public safety claims are not enough. Applied honestly, that framework makes Connecticut's position very difficult to defend. AR-15 pattern rifles and other semi-automatic long guns are unquestionably arms. They are not rare curiosities. By all serious estimates, there are tens of millions of such rifles in civilian hands, used every day for home defense, competition, training, and lawful recreation. Under Heller, that is the very definition of in common use. A state that wants to ban that entire category should have to show founding-era examples of governments banning commonly possessed defensive arms because some officials considered them too dangerous. Instead of doing that work, The Federal District Court and the Second Circuit Court of Appeals leaned on a different phrase, dangerous and unusual weapons. That language, drawn from historic sources and cited in Heller, was never meant to turn common, widely owned firearms into contraband by judicial label. Yet that is exactly how it was deployed. By declaring AR-15s unusually dangerous, the courts sidestepped the common use inquiry, treated the arms as effectively outside the scope of the Second Amendment, and relieved the state of having to prove any genuine historical analog. Finally, the opinion leans on a familiar trope because the founders carried muskets. Modern semi-automatic rifles supposedly fall outside the founding-era right. Bruen rejected that logic. The question is whether law-abiding citizens today are denied the commonly chosen tools of self-defense. By rebranding that denial as regulation of dangerous and unusual arms, the Second Circuit quietly but plainly revived the interest balancing that Bruen told courts to abandon. With that background, you can see why Grant v. Lamont stands out from the crowd of Second Amendment cases. Many lawsuits nibble at the edges of carry permitting or sensitive place restrictions. This one goes straight to the heart of the modern debate whether a state may criminalize ownership of the most popular rifle platform in the United States and still pretend it is merely regulating at the margins. The petitioners frame the question in plain terms. They ask the Supreme Court to decide whether the Second and 14th Amendments allow a state to ban semi-automatic rifles that are owned by millions of ordinary citizens and commonly used for lawful purposes, including self-defense. That matters because it forces the court to confront the common use doctrine it announced in Heller and has repeatedly cited since. If a rifle that outnumbers the Ford F-150 America's best-selling truck can be declared unusual, then the phrase has lost all meaning. There is also a national context that makes this case more than a local dispute. At least 10 states and the District of Columbia now enforce some form of assault weapon ban. Challenges are moving through the 1st, 2nd, 4th, 7th, 9th, and other circuits, producing a patchwork of opinions. Some courts have tried to follow Bruen faithfully. Others, like the Second Circuit here, have quietly resurrected interest balancing under new labels. Every time a circuit upholds a sweeping ban on common semi-automatic rifles, it emboldens legislatures elsewhere to copy and expand those restrictions, confident that the Supreme Court will remain on the sidelines. Grant is also unusually clean as a vehicle. The record squarely presents the core issue are AR-15s and similar rifles arms in common use or dangerous and unusual weapons outside the Second Amendment's protection. The petition is supported by data from sources like the National Shooting Sports Foundation, showing tens of millions of so-called modern sporting rifles in civilian hands. There are no exotic factual complications, no messy procedural detours, and no unusual plaintiffs that would allow the court to dodge the merits. For ordinary gun owners, the downstream effects are straightforward. A strong ruling protecting commonly owned semi-automatic rifles would undercut not only rifle bans, but also many magazine capacity and feature-based restrictions built on the same theory. If the justices apply Bruen as written, they could finally confirm that widely owned rifles, handguns, and shotguns still cannot be banned simply because politicians dislike them. If the court declines review again, the message to anti-gun states will be equally clear. Keep pushing, keep banning, and trust sympathetic lower courts to hold the line nationwide. While Grant plays out in the federal courts, a different kind of battle is underway in Minnesota, and it exposes the political strategy behind modern gun control. Minnesota has a firearms preemption statute, Minnesota Statute Section 471.633, which says in plain language that the state preempts all authority of cities and counties to regulate firearms and ammunition. Local gun ordinances that conflict with state law are void. The purpose is simple. A gun owner driving from one town to the next should not cross invisible lines where lawful conduct becomes a local crime. Despite that, the St. Paul City Council recently adopted a sweeping gun control ordinance as part of a coalition of like-minded cities. It purports to ban so-called assault weapons, large-capacity magazines, binary triggers, and ghost guns, and to restrict firearms in parks, libraries, and city buildings. Officials have been candid about their goal, not immediate enforcement, but political pressure. By putting a conflicted law on the books, they hope to push the legislature to repeal or weaken preemption and open the door to a patchwork of local bans. That admission is what makes this episode so revealing. When lawmakers concede that an ordinance may be unenforceable, yet adopt it anyway, They are not regulating conduct. They are shaping a narrative. They are counting on gun owners to hear assault weapon ban, assume the worst, and change their behavior even when the legal footing is shaky. For many citizens, the risk of being the test case is too high, especially when hiring a lawyer can cost more than paying a fine or quietly altering their habits. Unsurprisingly, organizations like the Minnesota Gun Owners Caucus have already gone to court, arguing that St. Paul's ordinance is facially invalid under Section 471.633. But win or lose in the short term, the episode exposes a disturbing mindset. If you cannot yet change state law or federal precedent, you can still pass symbolic bans, weaponize confusion, and let fear do the work that proper legal authority does not. Put Connecticut and Minnesota side by side, and the pattern is obvious. In one arena, officials defend bans on common rifles by stretching phrases like dangerous and unusual until they no longer resemble their historical meaning. In another, city councils pass ordinances they know collide with state preemption, betting that symbolism and confusion will achieve what the law does not yet allow. The tactic is the same: use process and fear to quietly narrow a constitutional right. For ordinary Americans, the cost is real. Most gun owners have jobs, families, and no litigation budget. Faced with a shaky ordinance or an overbroad statute, the easiest path is often quiet compliance. Skip the rifle, skip the magazine, avoid the park, and hope the rules settle someday. Governments understand that if they can keep the landscape uncertain, many citizens will disarm themselves in practice, even if doctrine on paper still favors them. That is why constitutional literacy matters. Knowing what Heller, McDonald, and Bruen actually say, and understanding tools like state preemption, changes the dynamic. It also explains why groups like the Second Amendment Foundation, Firearms Policy Coalition, Gun Owners of America, and state-level organizations are essential. No individual can fight every battle alone. The final piece is electoral city council members. Legislators, sheriffs, and attorneys general answer to voters. Litigation, education, and the ballot box together form a strategy rooted not in anger, but in citizens who know the law, value their freedom, and refuse to surrender it through silence or confusion. At the end of the day, cases like Grant v. Lamont and ordinances like the one in St. Paul, Minnesota, are not technical sideshows. They are stress tests of whether the Second Amendment still means what it says. Courts, legislatures, and city councils have made their moves. Now it's on citizens to make ours by understanding the law, supporting serious litigation, and voting out officials who treat constitutional rights as suggestions. If you found this breakdown useful, share it, stay engaged, and don't let confusion or fear do the work of bad policy. Freedom only survives when we defend it.